Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Everybody, welcome back to season 4 of 3Bs on the Law. We're all super excited to be back to share another season with all of our listeners. And of course, we're going to continue talking about employment and business issues that are important to all of us. So as we have always talked about, employers are required to provide a safe working environment, and having employees who come to work intoxicated or under the influence of alcohol or other drugs can pose significant safety hazards. Think of what could happen if you operate a manufacturing plant and one of your machine operators is intoxicated or one of your drivers is drunk. So today we're going to talk about having and enforcing a great drug policy that not only lets your employees know your expectations, but it also helps you to mitigate risk.
Right. Well, one of the first things you need to think about in your policy is what kind of policy do you want to have? A lot of people are familiar and have heard the zero tolerance policy concept, but there's also a second chance policy that you can put in place, or there are types of policies where you consider giving employees an opportunity to redeem themselves, for lack of a better word. So you need to decide if you want to go with a zero tolerance route, or if you're going to give options to, go to therapy or prove that you can refrain from drinking or, taking drugs again. And that becomes important because you have to make sure, if you have a zero tolerance policy, you can't give anybody a second chance, right? So your key salesman comes in and shows up drunk. You can't give that person a second chance. So
Yeah.
Yeah,
I also think it's important to understand too, just before you make those decisions about whether you want them in the policy, is that individuals that are recovering alcoholics have protections under the Americans with Disabilities Act. And so, it's important to understand those things, that as they come back and they're trying to recover and how that looks for them, that they may need some type of accommodations, and you may need to accommodate them in those ways that you may have not originally planned when you made the policy. I mean, don't you guys think the same?
I do. And, in California, if you contract or get grants from the state, you actually are required to have a drug-free workplace. We actually have the California Drug-Free Workplace Act of 1990 that requires employers who contract with the state to do that. But I think that a lot of other employers, especially Trisha, you made a great point with the ADA, if an employee comes to you and says, comes to work intoxicated and beats you to the punch and says, hey, I need to go out on disability leave because I have an alcohol problem. It presents an interesting factual scenario for an employer.
Yeah, I think in some states you're gonna have the right to let the employee go. Obviously, if they come to work drunk, that's not going to be acceptable in any state, probably. But I think the problem is just having. I'm always concerned that people don't recognize what is truly a disability. They think it's something like, someone's blind or they're missing, have lost an arm or a leg or something. So it's like this obvious thing, but there is a recognized disability in someone who's recovering from drug addiction or alcohol. And so I just think that's important to have an understanding of, so that those people, so that you don't make missteps. If they come back to work and they do say, hey, and they're not like coming to work and intoxicated, but they're actually come back to work, say you give them that second chance, Susan says that's part of your policy. They're working for you. And then they say, I need to go back and get some help. You may need to accommodate that under, and that's kind of where I was going with it. But I think you make a good point, Camille, because that it certainly depends on, contractual requirements, even if they're not like state required, you know what I mean? It could just be a requirement of the type of company that you're working with, that your employer works with, like, whether that be with schools or private schools or public schools or certain institutions that may require that you have these type of drug-free policies. And so those are all important things to think about when you're trying to, cultivate what it is your policy is going to look like, because you really can't, like Susan said, get into it and then go, oh, but this employee, we want to make a different choice for. So how are you going to, handle it, even if, your best employee is under that situation? That's the way, I think is a good way to look at it.
Yeah. And so I think the next big thing to talk about really is, once you have your policy, you need to define when you're going to test your employees. And so, Susan, what do you think about how employers should go about outlining when to test their employees?
Well, they need to decide if they want to have, do you have to pass a test to start work? Do you need, do you want to impose a random testing, or do you just want to wait and test after an incident is, or if you have a reasonable suspicion that someone is, is drunk or under the influence? So it's really depends on how much the employer wants to do that testing. And in some of these states, it gets so complicated where marijuana is legal, right? It adds complication to what you can and can't test for, or if you're going to get marijuana results, if they were legally able to, a positive marijuana test on hiring can't necessarily be used to prevent someone from working for you because it's legal. They weren't on legal.
I actually disagree with that. I think that because it's federally illegal, I think that's an employer by employer decision whether they're going to allow that or not. Like, for example, if you have truck drivers who are doing interstate driving for you, no drugs, they have to test negative for everything. There's no kind of exception to that. Whereas other, if you work for the local grocery store, they may allow, employees to test positive for marijuana.
I guess it depends on if you're getting federal, if you're having federal money, or you're talking about with interstate commerce with the truck drivers. But again, I'm talking about a pre-hiring test. I think you have to be careful with that in a state where it's legal, because they haven't committed a state-based crime and they're not on the job yet, right? So at least here in Illinois, there's processes that people have the right to go through and contest, and they, it's very complicated. So I just would say to people, as I say to my clients, you don't want to be the test case, do you? So you can have a drug-free policy, but it's the hiring question that I'm speaking to. But then there's random, and that would be different. If you have a drug-free business and you do random drug testing and they test positive as an employee, now to me, that's where I agree with you. That's where, wait a second, no, drug-free, you cannot have drugs in your system while you're operating the vehicle. We can't, establish when it was. So that can be an interesting question. What about you, Tricia, down in Texas, where marijuana is still illegal, I believe, correct?
No, marijuana is not totally illegal here.
It's legal there? Oh, sorry. I didn't realize. Are there any states left where it's illegal? Who knew?
So there's an allowance for medical marijuana in Texas, very limited. So most Texans don't know about it because it's only it was originally for very limited conditions like epilepsy. And then they have opened it up more recently and allowing for, but most of the conditions are very like severe life-threatening conditions where they will allow for some medical marijuana. And there's only like, I think 2 or maybe 3 places that you could possibly get it from. It's just, there's a lot of limitations here, and it's very expensive apparently to even, and I'm assuming there's a lot of politics to getting that license because it's very expensive here. It's not like when you walk down Venice Beach there over there in California. It's a little bit different scenario here. Most people, when I tell them that, they are like, I thought it was completely illegal in Texas. And it really is for most people. I mean, if you have a severe condition like that, you have to go through some hoops to get, most physicians probably are not engaging in that and aware of it as much as using it. But it is interesting because Texas is moving a little bit. It's just, it would probably take, the federal government's probably going to move faster than Texas, to tell you the truth.
It is readily available to, anyone of legal age in California can go down to their local shop and purchase marijuana if they want. But the interesting thing in California is random drug testing really isn't allowed except for under very limited circumstances. And so, that's one of kind of the interesting things. The only time in California employers can conduct what we call kind of a suspicion list test, where there's no indication that someone's under the influence, is upon hiring, but before the employee begins work. And so, your policy needs to really specify, at least here, I think, whether or not you're going to allow marijuana. And if so, what the standard is. I think one of the issues with marijuana is, how do you really gauge whether someone's under the influence if they test positive? Because it stays in your system for quite a while. And so I think that's one of the things that, even though it's been legal here for quite a while, at least to me, it doesn't seem like there is a standard for what the level is on the test for someone being under the influence, if that makes sense.
Right, for proving how long it's been in your system, right?
Correct. You don't want an employee coming to work high, for sure.
Right. Well, that's where I found that before the legalization in Illinois, this reasonable suspicion checklist wasn't something that I found a lot of employers were using consistently or talking about. And then when said, well, how am I supposed to know with marijuana, when it was in your system, or if they were, how do I show that it was, that they were under the influence? And I said, there's your reasonable suspicion checklist, right? Let's go back to that. That can be key to determining whether or not someone should be sent for testing, or to back up your reasoning to send someone for testing.
Right. And so reasonable suspicion, obviously when someone's intoxicated, you see slurring speech like I just did a second ago. Uncoordinated movements, dilated pupils. And you really want to make sure that you detail these symptoms, at least in California, since you can't do random testing. You want to make sure that you have really documented these observations, and have, obviously video, I think, is always the best, or photos of the employee demonstrating those types of behavior.
Yeah. So that's a little different than Texas. Here we don't have a lot of rules about it. They let the employers, make these policies, the way that they see fit. So there's not going to be a lot of limitation if they want to do random. I think the problem I always see is that, do you really know what random is? And random isn't, I would randomly like to test that group this week because I think there's a problem there. Like, that's not random. And so I've had that conversation a couple of times with employers trying to work through these issues. And I'm like, no. So when I think what you're stuck with here is that what you call it is what you get. So I always go through these 4 and I say, well, what do you want in the policy when we're looking at the handbook and crafting it? And, you can't decide all of a sudden you want to do it for this particular person. You're going to have to be consistent. And if you're really going to do random, I always tell them, don't put it in the policy that if you were like, someday, somewhere over the rainbow, I'd like to do random testing. You know what I mean? Like, right. If you really want to do random testing, you need to kind of step in to that circle and do that. And even if it's once a year, I think you need to commit to it being truly random and having really understanding what that is. Otherwise, it really is more, I think, the reasonable, suspicion. And then you're going to have to, we don't probably maybe have as strict requirements as what you guys are talking about as these tests, but like, as far as you are going to need to be able to prove it to some way. You're going to have what, a reasonable person would consider to be, something reasonable, raising that level of suspicion that there is some type of use there. And so I think it can be confusing if they don't really understand like what all these things mean, if you do have the options for all four, like you may have here in Texas. So you got to figure it out and kind of understand how this is going to work like day to day. And are we going to treat everyone the same? Because the worst thing you want is some type of evidence that you're creating, you're drug testing, a certain type of race or religion or sex or something to that effect, and creating some type of discrimination out of
right. One of the things I always, in a drug policy that I always want to see is that there's going to be a drug test if there is an incident. So like one of your employees is involved in an auto accident, it really protects you. If you send your employee to have a drug test who's involved in an accident, or, even an accident in your facility, it doesn't even have to be a traffic accident. But let's say that there is, an OSHA type accident at your facility. You want that hopefully negative drug test. And if you don't undertake that kind of testing, a good lawyer is going to imply that testing was not done to cover up the fact that the employee was.
That's like a good lawyer, like Camille.
It's kind of like a double negative. So I think that you really want that test to protect yourself.
I've had that conversation because there's the option here of like not having any drug testing policy, right? And so like, I've had that conversation so many times, Camille, and I almost like don't let them leave the conversation without me going, you may not want drug testing, but like, let's go through this again. Above all the drug testing options, don't you want the accident option? Because like, how could you not get that? Like, it's just such an exposure. Like, I've had employers call me and be like, so-and-so employee just got in an accident on the state freeway, hit some sign owned by the state or something. And you're like, and I'm like, why are you calling me? And they're like, what do we do? What do we do? And I was like, you have a policy for this. You need to have them drug tested. Like you need to have a relationship with somebody who's going to do the drug testing, unless of course, if the cops are involved, it's probably going to happen anyway, but like they sent to the hospital, like you have a plan, not just like, let's just adopt some stuff here and figure it out. And certainly with the incident, I'm a big fan. Like if there's an incident, you're concerned there's some sort of physical injury with your people, your team, or other people, or damage to property, then yes, there should be like testing. I'm all about that, Camille. It's once you say that to them, they go, you're right, we do need that. That's a good idea. And then they almost always agree to have at least that in there,
Yeah. And so that brings up someone has an incident. How do you go about getting that test done? And I think that supervisors need to be trained on what to do if they have an incident, because many of my clients, they actually have someone who is designated, if there's an incident, to actually go to the accident scene and drive the employee.
Agreed.
To the place to have the drug test. So that way, one, God forbid the employee's drunk, you're not sending him drunk, to drive now to the testing facility. But you also have a supervisor who's there to document the fact that he took the employee directly from the accident scene to the drug testing site to be tested. So there's no
shenanigans.
The employee having, cousin Charlie or whatever go take the test for him.
Yeah, I call that shenanigans, some sort of shenanigans.
Shenanigans.
So they
All right,
stopped the bar on the way because they were nervous about taking the test. And now suddenly there's no evidence, right?
Yeah, and then you're stuck with a weird. I couldn't get to the drug test place. I got confused. You don't get the test, and then you don't get the evidence of whether this employee needs to be let go or not. If it's, you know what I mean, if you have no tolerance for policy, so it's really important to get that evidence because it can make a world of difference in all different ways. And you won't know within those 24, 48 hours whether or not you will need that test. You'll find out later because, if there's some personal injury lawsuit that comes out of that, that's not going to pop up on your radar for possibly months. And so, you will want that evidence to secure what exactly happened, who was at fault, or to defend your case that, that possibly if the employee wasn't on any sort of alcohol or drugs, and that they were trying to act reasonable in the situation, if they were driving a vehicle or operating some type of machinery or something, it can be really, really important. So, and you just have such a short time frame if it's alcohol to get it. It's so short. If that employee goes home and then goes to the hospital, now there's a question there about whether or not the alcohol faded from the system to some extent if you miss that time frame. And they'll tell you that I think you should always, if you're going to go into the world of drug testing, you should have a relationship with, I would say, one, if not more, drug testing mobility places where you can send them out to the site, or you have a place. If you have your employees in vehicles running all around the city, you should have I would get in contact with a drug testing site that has multiple locations around the city so you can access that. They're not having to drive an hour and a half back to some drug testing place next to your office, because chances are, if they're driving all around the city, they're not going to be right next to your office if some incident occurs.
Right. And there are places where a lot of employers, you can contract with an industrial medical facility that specializes in drug testing, where you can send your employees for their pre-employment drug testing, along with your reasonable suspicion drug testing, and along with your post-incident drug testing. So that's something to really think about as you're drafting your policy.
Yep, I think that's good. I think we covered all the things we were thinking about covering when we thought of doing this episode. What do you guys think?
Yeah, I think it was a great episode. Thank you so much for joining us back on season 4 of 3Bs on the Law. Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.